Now, you might wonder why I should think that opening these proceedings, broadcasting, making them more available to people in a high-profile case would be helpful. You might initially think, well, this is simply going to raise the temperature. It's not going to lower the temperature. I think that's incorrect. Here's why I think it's incorrect. First, we've all seen the kind of coverage that occurs in high-profile cases. Images on the television news of people coming and going to the courthouse with whatever they're coming and going to the courthouse from, and sometimes in various states of various circumstances. These images of the lawyers and the parties crowding through onlookers amidst a demonstration, sometimes outside the courthouse, hardly is a scene of judicial tranquility and calm. The images that are sketched by the sketch artists of the proceedings hardly reflect the kind of image that you would associate with an orderly trial proceeding. And from the lawyer's point of view, I believe that lawyers would find that broadcast of the proceedings themselves would be sedentary. It would lower the intense pressure on lawyers to be making statements to the media before or after the trial, before or after the proceedings. I'm not saying for a moment that the media will not ask questions. The media will not try to get a story. Of course they will. But you will have a ready answer when you're asked, what about this evidence? What about this testimony? What about this, that, or the other thing? And you can simply say, look, you saw what happened. And your viewers can see what happened in court. You don't need me to tell you what happened. I think it would get you as lawyers off the hook of having to serve as part-time public relations individuals, as spinners of the story in a way that hasn't been fully appreciated. In any event, I don't know whether you agree with that or not, but in any event, that's what I think would be a step in the right direction. Okay, lesson number 3. Make nice to the media. Now, make no mistake about it, the media are not your friends. Especially in this high-profile case. But they're not exactly your enemy either. So don't treat them as such. The media, of course, are looking for the man bites dog story, of course. And it's generally easy, much easier for the judge to decline talking to the media or dealing with the media in a high-profile case because the media folks almost invariably understand the limitations on what a judge can say or do with respect to a case that the judge is presiding over. That is not anything that the lawyers can rely upon, of course. A judge in a high-profile case can do a lot of things to help both himself or herself and the lawyers maintain a cordial relationship with the media and get a reasonably accurate story of the proceedings out. First, and if the judge doesn't do these things on himself or herself's own initiative, there's no reason why the lawyers cannot suggest these things. Probably such suggestions would be appreciated by most judges. First, appoint someone on the court staff to interface with the media. Best, of course, is somebody who's unflappable, somebody who understands something about the news business. In the Northern District of California, we had for a number of years a person whose uncle had been a long-time reporter for the San Francisco Chronicle. She grew up in a household where there were newspaper people. She knew the business, and she knew lots of the ways that media look at stories, and she was understanding of their needs and also the limitations that they were operating under. And she proved to be a wonderful point person in the clerk's office in dealing with the media. And that relieved the lawyers of a good deal of the necessity for interaction with the media. Secondly, an overflow courtroom in which the trial proceedings are transmitted is extremely helpful. Most reporters prefer to watch the proceedings in the overflow courtroom than in the courtroom itself, because they can come and go as they like. They can pound on their laptops, they can talk to others, they have a lot of flexibility in the overflow courtroom that they do not have in the courtroom itself. And in the Prop 8 trial, for example, we established a ticketing system to ration the limited seats in the courtroom and set aside a certain number for the media representatives who did prefer to be in the courtroom itself. The ticketing system worked extremely well in that case. And we had no empty seats in the 13 days of trial. Another very useful step we took was to alert the press and the parties in advance of the issuance of rulings. This is very helpful to the lawyers. And if the judge doesn't suggest it or otherwise indicate that he or she's going to do it, there's no reason why the lawyers could not suggest to the judge that the lawyers be given an advance look at the orders or the rulings as they're issued. Either an hour, 2 hours, maybe a day ahead, whatever. I noticed that the California Supreme Court has, for several years, been in the habit of at least alerting the lawyers that the decision is going to issue on such and such a date. We went even further in not only the Prop 8 case, but other cases, and that is giving the lawyers copies of the orders in advance of the actual filing of the orders. Sometimes a matter of hours, sometimes a matter of 24 hours. The advantage of that is, of course, that the lawyers have the order, they have what it is that they're going to be asked about. They are not having to answer the media's question on the fly. They can give a more complete response and a much better informed response than they can without advance notice. The deadlines in the media business these days are down to minutes, not days, and certainly not even hours anymore. So it's important that the lawyers and the trial participants have enough information about what the court is doing so that they can respond meaningfully to the media. Now, as I said, lawyers have a much harder time of avoiding media contact than does the judge. But there are a few simple rules, I think. First, don't let the press talk to your client without being present, and indeed, keep your client away from the media if you can altogether. Second, try to know the reporter who you're talking to. Will the reporter abide by the rule that what's off the record stays off the record, or will the reporter not do so? Third, remember that the judge will likely read or see what you say about the case to the media, and the same goes for the jury. No matter how many instructions are given to the jury about not reading newspaper reports or listening to radio or television, the chances are what appears in the media is going to be seen by the judge, it's going to be seen by the jury. You simply have to recognize that. And fourth, if you do talk to the media, make sure your comments are consistent with the theme of your case and the evidence of the trial. Lesson number 4. Rise above it. The judge handling the high-profile case will try not to get in the way of the case or the media's story about the case. This means, in my view, that what's going on in the judge's life outside the courtroom and in other cases, the duties the judge is fulfilling should stay out of the case at hand. The judge may be criticized in the media, may receive threats of violence or intimidation related to the case, and may encounter well-meaning friends and acquaintances who want to draw the judge out about the case. The judge should certainly rise above this and act in the courtroom as if the case at hand is the only matter on the judge's mind. And these same basic principles apply to lawyers. We all need to remember that a case, even a high-profile case that involves explosive issues, is not about the lawyers, it's not about the judge. In some cases and at some times, a lawyer's tactics and skills will be called into question by the press, by commentators, by the public. The law professors, I've found, who respond to media inquiries are sometimes pretty wide of the mark in commenting on the proceedings. And because they're identified with an institution suggest a good deal of learning on these subjects, more attention is paid to these comments than I think they are worth. And it's not entirely the fault of these professors who are called upon to comment. They may not be given the full story. They may not have access to all of the information. They may be responding to an inquiry in the press that doesn't paint the full picture of the situation. But you simply have to deal with the possibility that there will be comments from individuals who are supposedly very credible, who are making statements that are difficult for you to deal with. So I realize that applying some of these lessons in the context of a case where the pressure is high, where the scrutiny is intense, where the stakes are consequential, calls upon your very best instincts, both professionally and personally. And there will undoubtedly be irritations, there will undoubtedly be disappointments in these kinds of cases, no less than in any other kind of case. These are really the cases that test your mettle as professionals, not so much in your skills as a lawyer, not so much in the sterling quality of your advocacy, but tests you in a way going to your character. And that character stands out in a high-profile situation. You just want to be sure that when you're in that kind of a situation, the best of your character does come out. And I'm sure if you think about all of the other participants in the proceedings, particularly thinking of it from the point of view not just of your case, but of the integrity of the judicial process and how this enterprise that we as lawyers and judges are involved in works, that will be your lodestar